Hello everyone, I'm attorney and professor Kirk J, and I want to welcome you to the third in our mini lectures on issues in employment law. Today we're going to be talking about Title VII of the Civil Rights Act of 1964. However, before we go any further, I want to caution you that what I'm going to present to you today is for educational purposes only and is not meant to be legal advice. If you are facing a serious issue at work, I recommend that you contact an attorney who is licensed in your jurisdiction. Now, what is Title VII of the Civil Rights Act of 1964? The Civil Rights Act of 1964 was a general law passed by Congress that prohibited discrimination in many aspects of American life and work. Title VII specifically is the employment provisions of the Civil Rights Act. Title VII applies to any employer who employs 15 or more employees, and it should be pointed out that it does not cover an employer who has less than 15 employees. So what we're going to talk about in our mini lecture today is only going to apply to those employers with 15 or more employees. In general, Title VII prohibits discrimination against employees or applicants for employment on the basis of race, color, sex, national origin, or religion. Now, Title VII, in a legal sense, prohibits two separate types of discrimination. One is referred to as disparate impact discrimination, and the other is referred to as disparate treatment. I'm not going to spend much time on disparate impact other than to describe it very briefly. And disparate impact occurs when an employer's policy or procedure, which on its face is neutral, gets applied in the employer's workplace, and folks who are in one of those 5 protected classes that I mentioned are disparately impacted. In other words, a group such as women are impacted by this policy once it's put into play. You wouldn't be able to tell that it was discriminatory policy until it's actually put into play. Now, that type of discrimination is more and more rare for a number of different reasons, including sophisticated HR departments who are making sure that type of discrimination does not occur. The other type of discrimination that's prohibited by Title VII is disparate treatment. Disparate treatment is intentional discrimination, and probably when most of you think about discrimination, you were thinking about one-on-one discrimination from a supervisor discriminating against a subordinate. That is disparate treatment discrimination. The big issue with any discrimination case is, how am I going to prove as an employee or applicant who believes I've been discriminated against on the basis of my race or sex, color, religion, national origin? How am I going to prove that I was discriminated against? Well, the Supreme Court has provided really 2 methods of proving that you were subjected to discrimination in employment. One is what's called direct evidence, and the other is indirect or circumstantial evidence. Direct evidence is very easy to understand. Direct evidence is any evidence that a jury could hear or see that the jury needs nothing else to conclude discrimination occurred. In that case, the only things that would suffice to be direct evidence would be things like direct statements from the employer. I am not hiring you because you're a woman, or I am terminating you because of your race and replacing you with someone else. As you can all imagine, that type of evidence rarely exists, so most employees have to proceed on an indirect or circumstantial evidence case. The Supreme Court has given us a very specific way of proving this. And what the employee has to do is offer what is sometimes referred to as a McDonnell-Douglas case. In other cases, attorneys refer to it as a burden-shifting case. Initially, the employee must offer evidence of 4 factors. One, they must show what protected class they are in, so the discrimination is directed against me because of my race or color, etc. Then the employee must show that they are qualified for the position that they held or the position that they sought. Next, the employee must show they suffered an adverse action. Adverse actions can be thought of as things that affect your wallet, in other words, affect your money. So failing to hire you, firing you, failing to give you that promotion that would give you a pay increase, those are examples of adverse actions. And finally, the employee must offer some other indication or some other amount of evidence that shows that their protected class, race, sex, etc., played some role in this. So for example, if they're applying for a job and the person who is applying is female but a male gets the job, that would be an example of another piece of evidence that indicates that sex played a role in the decision. If the employee can offer evidence on those 4 items, then the burden shifts to the employer to offer a legitimate, non-discriminatory reason for the adverse action. Now, this can be anything in the world, and since many states are employment at will jurisdictions, any reason suffices. So as long as it's not related to discrimination on the basis of a protected class, then in fact, it is a legitimate non-discriminatory reason, or allegedly so by the employer. Because if the employer comes up with that legitimate non-discriminatory reason, the burden shifts back to the employee, and the employee must offer evidence that that alleged legitimate non-discriminatory reason is in fact false. It's pretext. It's not worthy of belief, and therefore the employer's house of cards falls down, so to speak. It's important to remember that if you are alleging discrimination on the basis of any of those 5 factors or 5 classes, that you have a limited amount of time to begin your legal claim. That legal claim must be begun, in most cases, within 180 days of the date of the discrimination. But in some courts and some jurisdictions, you are allowed up to 300 days to file with the EEOC or an appropriate local agency. However, it's very important to remember that you must move through this as quickly as possible and not delay. It is also important that you seek an attorney who is experienced in handling discrimination claims, because these cases are extremely complex and hard to win if you are an employee. Again, I'm attorney and Professor Kirk Angel, and thank you for listening to our lecture.